The Supreme Court has issued its final decisions before heading into a summer recess. The justices ruled in favor of Arizona's Republican-backed voting rights case. The decision was a 6-3 split along party lines. The court says neither of the state's voting restrictions violate Section 2 of the Voting Rights Act. Democrats had challenged Arizona's legislation, which prevents third parties from collecting and delivering completed ballots to drop-off sites. The court also upheld a longstanding state policy requiring election officials to throw away ballots accidentally cast in the wrong precinct. Arizona Democrats accused the state of historically shifting polling place locations in an effort to limit minority votes. Joining us now for more on this is Ilya Shapiro. He's the vice president of the CATO Institute and director of the Robert Levy Center for Constitutional Studies. Ilya, welcome. Thanks for joining us. So, Arizona Democrats argue that these voting laws are restrictive and have a disproportionate impact on the state's minority voters. However, state Republicans allege these rules are simply necessary to eliminate third-party ballot harvesting and voter fraud. Can you break down the law in question for us and highlight the pieces of it that are considered most questionable by the Democrats, and then take us through the Supreme Court's decision?
Sure. This was a bad case to bring. I think a lot of voting rights activists, a lot of progressives were questioning the DNC, the Democratic National Committee, for challenging these particular provisions because they're so commonplace around the country. A lot of states prevent ballot harvesting, that is, people who aren't your relatives or the postman from touching your ballot, going around to collect third-party ballots, or requirements that you vote in your actual precinct if you're going to vote in person. Those are pretty standard, very common, nothing that was passed in the last year or two, during the current debate or what have you. And what's interesting about this case is that this is the first time that the Supreme Court considered a challenge under the Voting Rights Act, under Section 2, which is meant to stop race-based vote denial, for something other than redistricting. That's because 8 years ago, the Supreme Court in the Shelby County case disabled a different provision that required Justice Department approval of electoral changes in many states, including Arizona. But anyway, the court decided that both of these provisions, as I said, which are pretty common across the country, do not violate that key provision of the Voting Rights Act because they don't cause a huge burden on minorities relative to whites, because it's not an uncommon type of burden that's put in place. There's kind of a lot of factors that courts are to consider that the Supreme Court gave guidance to. But at the end of the day, they said this was kind of a common rule, that there's no showing that it was racially motivated or that has a huge or disproportionate impact on members of racial minorities.
So then, citing that fact, does today's ruling then not have a huge impact on the 1965 Voting Rights Act or the power of that Voting Rights Act, since, as you point out, even some, progressive activists question whether this was the right law to bring before the court?
Well, it will certainly affect lawsuits like the one that the Justice Department filed last week against Georgia's recent election reforms. Basically, the court today said that if you're bringing a claim of race-based vote denial, you actually have to make out that claim. You can't just say that, some small statistically insignificant difference in voting between racial groups, that's enough. That's not the case. There's a lot of flexibility, and unless you can effectively have a smoking gun of state officials saying they want to deny minorities the right to vote, or the size of the disparities is huge, or there's just something really unusual going on when you consider the whole range of election regulations, then that's going to be a very hard measure to stop. So in other words, it's not just a matter of any time you cut the number of early voting days or the hours or something like that, that's going to be some sort of violation. If a state still makes it easy to vote with mail-in and lots of alternatives for absentee voting and what have you, a tweak here or there is not going to be sufficient to take down the law.
So let me ask you something then. Does it have to be something more specific, like limiting Sunday voting, for instance, in areas where it's cultural for a lot of congregations to go after services to the polling places? Do you have to be that specific that you can draw that sort of through line, or is that not even specific enough?
It could be in cases like that. It's the souls to the polls restrictions, which were not in place in Georgia, for example, among other controversial laws that are in the news now. There's probably evidence there that there's some intent to stop that category of voters from going to the polls or making it harder for them. But in general, the court didn't draw bright lines today. They laid out a number of factors which aren't exclusive, but really it comes down to how much of a burden on voting does a particular rule impose, and is there a huge disparity between how it affects members of different racial groups.
So looking forward, what kind of precedent does this set for other states enacting these similar restrictive voting laws in the future? I mean, you mentioned that it doesn't look good for the federal case against Georgia. What about other states?
Well, it depends, and I wouldn't necessarily call them restrictive voting laws. It's much easier to vote now anywhere in the country than it was even 10 years ago. We didn't have early voting anywhere until after Bush v. Gore in 2000, and lots of states were completely revamping their electoral processes. And by the way, Florida learned a lot from that. I think Florida has one of the best-run election organizations anywhere in the country, and that's why, even though it's a swing state, we learned their voting results within a few hours of polls closing on election night in November, which isn't the case in a lot of other states that provoked the frenzy that we've seen ever since. But at the end of the day, this is it's basically a smell test. Is there either a racially discriminatory intent on the part of a legislature? Is it, as you said, closing on Sundays when it's well known that that's when a lot of especially black congregations tend to take their voters to the polls? But it's kind of if something is commonplace, if something's been around for a long time and there haven't been complaints, and all of a sudden another state does that doesn't make it problematic. So it's really kind of as I said, a totality of the circumstances. Lots of different factors to consider, and you look at overall, does the state make it easy to vote?
So in the court's second and final decision for the term, Ilya, the Supreme Court struck down California's donor disclosure law. The ruling states that the law is a violation of the First Amendment and nonprofits are not required to disclose any of their major donors. So can you break down this ruling for us and the significance of the decision?
Right. This one was also 6-3 along sort of so-called ideological lines, which is a rarity this term, I must say. But both of today's cases were that way.
Yeah.
And there was a big property rights case about a week or 10 days ago that was also that way. But that's a rarity. There were only, I think, 15 cases this term that were 6-3 or 5-3, and most of those were in kind of all sorts of heterodox splits. So the 6-3 conservative court that people were expecting or fearing or hoping for, that did not really materialize this term. Anyway, this case brought together a lot of odd bedfellows, cause organizations across the political spectrum, whether it's my own CATO Institute, whether it's the ACLU, the NAACP, a lot of different organizations challenge this donor disclosure laws, as well as charities that have no political salience whatsoever. The idea is they have to provide the state with the identifying information for all their donors, and they didn't like that because that chills association, that chills the speech of people who want to get involved in these nonprofit groups. And like the case of the NAACP almost 70 years ago versus Alabama, the Supreme Court said that the state does not have a strong enough interest in learning of those donors. And on the other hand, there's a chance for harassment or facilitating harassment when people learn, whether by leaks or website disclosures, about who these donors are. So, some people, there's a debate about how much of this disclosure ruling today will carry over into political campaigns. But this case, to be clear today, the holding today was about nonprofit organizations, not election regulation.
Interesting stuff. Ilya Shapiro, thank you so much for shedding some light on these new decisions for us. We appreciate it.
Thank you. And no word yet whether Justice Breyer is retiring. It could still happen. It might not.
All right. We'll wait and see. Thank you.